I want to bring in civil rights attorney Jim DeSimone tonight to walk through some of the legalities here. Mr. DeSimone, legally, is an investigation or punishment different if you've shot a child rather than an adult?
I think ultimately the punishment could be a big difference. If you're shooting a minor, it makes a difference. But I think from the police perspective, the investigation is going to take the same course, especially here where you have a 16-year-old. Well, of course, he's in the hospital at this juncture, but he probably will at some point be able to relate exactly what happened on that day.
And that we're kind of in this middle ground right now, where if the injured party is not able to give a full account, and if the suspect presumably is not talking with police at length, what happens? Do we just sit in limbo?
There's a lot of circumstantial evidence here. The injured youth may not be talking, but his parents are. And we know what happened that day, that he was sent to, at least from the parents' perspective, an account that he was there to pick up siblings. He went to a house 1 block away with a similar address. So certainly the circumstantial evidence appears that there's no ill intent. And then we have the physical evidence of a crime, which is that he, in fact, was shot in the head and his shoulders.
Okay. And then we know the shooter allegedly shot this boy a second time as he was going down. Would that be considered a sign of excess, or could it be argued also that that's proof that this person feared for their life and thought, okay, I still have to neutralize a threat? Like, where would that go legally?
I think we have to remember that it's not just enough to have that subjective fear. Under Missouri law and under most use of force statutes, even those that apply to the police, the fear has to be reasonable. And he has to be under a reasonable fear that what he did was to protect him or others from an imminent threat of force. Someone ringing a doorbell, someone knocking on a door doesn't really rise to that level. So shooting him the second time, I think the better evidence would be is that this was just unreasonable. The guy's going down. He's clearly unarmed. He's a 16-year-old kid. And if you're shooting him a second time, you're really not in reasonable fear of your life. So it could actually be used to result in a conviction rather than an acquittal.
You were just talking about stand your ground, Mr. DeSimone, and of course it changes by which state you're at. And so this is Missouri, my home state, and I believe if you feel threatened, you're able to shoot if you think you or someone else is in immediate danger. If this boy thought, okay, I'm going to a friend's house, I'm gonna pick up my sibling, would it make a legal difference if he were knocking on the door versus if he was jiggling the handle or if he was even coming through the door?
I think the latter part of what you said. I mean, if he's actually just, without being invited, walking into someone's door and a person is in fear, then you could say that that was a more reasonable fear in thinking that they were under a threat. People usually wait for a door to be open and invited in before they walk into others' homes, and especially here where he's at the wrong house. But again, that fear or that concern on the part of the shooter has to be reasonable under the totality of the circumstances. And if it's just jiggling a door handle, that does not appear to rise to the level of a threat to that individual and should not have resulted in shooting an otherwise an innocent young man from all accounts, as far as the information that we have so far.
Walk me through the legality of what you just said, if you would, because if someone says, I heard someone jiggling the door handle, I didn't know who was on the other side, we've had burglaries, or I've heard of assaults or something like that, and I was scared that they were jiggling it, they're coming through, that does not rise to the level of reasonably protecting yourself.
The person who has the gun has to reasonably believe that that person is using or is in the imminent use of unlawful force. And a person who's just standing there, even if they've jiggled a door, is in no way showing that they're imminently going to use force against the person on the other side of that door. So I would think that shooting under those circumstances, I mean, the stand your ground law, if that is allowable under a stand your ground law, then the law goes too far in protecting individuals to just shoot people just because they happen to be on their property.
Many unknowns at this point, but as you say, there are some laws on the books. Civil rights attorney Jim DeSimone, thank you.
Thank you very much for having me today.